Hello and welcome to Moneylife. This is Sucheta Dalal. We are once again going to talk about Anugrah. Why are we talking about it so much? Not just because it is 1000 crores, which is a lot of money, but the case is throwing up new things and new learnings every day. In fact, those of you who are interested or who've been trading with brokers or who have lost money to half a dozen others who have defaulted in the last 2 years may want to look at some of the other things that we have done, including how to file a complaint with the National Stock Exchange. There is a separate video available. Please go to Moneylife TV and you will find the videos there, including how to do the arbitration proceedings before the National Stock Exchange. Now, what are we going to discuss today? A new development that has come up in the Bombay High Court. So, what happens is Anugrah is promoted by somebody called Paresh Mulji Kadia. He has filed an affidavit because about 37 investors have gone to court and demanded arbitration before the Bombay High Court. The Bombay High Court has issued an interim order asking him to not alienate some of his properties. It's a small amount. But what Kadia has done is that he's filed an affidavit in response to these petitions in the Bombay High Court where he's made a stunning charge. So again, it's not something that our readers don't know about, but this is now formally putting it on record in an affidavit. What does it say? It says that Edelweiss Custodial Services, remember this was his clearing member right until July 20th, which is just a little before he went belly up. Now, Edelweiss Custodial Services, he says, allegedly sold 420 crore worth of client shares, mutual funds and securities on 26 separate occasions between 9th March and 7th May 2020. And they did this without first looking at whether there was a cash collateral and whether there was a bank guarantee available, which is the normal practice. Now, he says that ECSL did not exercise reasonable care and diligence, and I'm reading from his affidavit, as a consequence, in some instances, it's very probable that securities may have been improperly sold by ECSL. This is a charge that we have checked with Edelweiss, we've checked again, they absolutely deny it, and this time they haven't even bothered to reply to us. So, what happens now? So, it actually opens a can of worms. So there are two things that he's done. Remember, this 1000 crores, and this whole thing came to a head when the National Stock Exchange discovered that he was running an unauthorized derivatives advisory service through a company called Om Shri Sai. This was all before August 3rd. That was 165 crores and already closed. Step 2, we have noticed that he managed to convert those clients into direct lenders and he told them, I'll give you the same returns. So they are in deep trouble. We then discovered that he had another sort of sub-broker entity called Teji Mandi Analytics. This entity had collected 800 crores, was running a similar derivatives advisory service, also unauthorized. All the trades were through Anugrah. Now, in this court affidavit, he just washes his hands off all of that and he says, I have nothing to do with clients of TMA, which is Teji Mandi Analytics. They need to go and take up their issue with TMA and they can't come to me. This is a whole legal issue that's probably going to be heard by the court, because when TMA operated through him, whatever he did, is it even permissible that you are running trades, you have opened broking accounts and you say that I have nothing to do with them? We don't know. It's a test case, but it's a lot of money. It's over 1000 crore. It's in the Bombay High Court. 37 cases have been filed. There was a hearing today as we speak. Another 60 odd cases were supposed to be filed, and there are a few hundred others who are going through some other lawyers. Now, let's look at what else has come out in this can of worms. So there are two interesting developments in terms of what has appeared in the affidavit. One is that Paresh Kadia has declared his assets, and it's a bunch of flats. And for those of you who appeared or who attended that NSE seminar, you will know that the National Stock Exchange also says that the total amount of assets or value of assets that he is declared is just too tiny to cover this 1000 or 1200 crores that he owes people. And sure enough, he's got half a dozen flats and offices that he's talked about, and we're showing you a chart from the affidavit. These are just too tiny. They're not going to cover anything. it would mean that he just confirmed that he was running a Ponzi scheme, and new money that was coming in July and August may have gone to pay off earlier investors and to cover up the losses. So the question that arises is, what is the way forward? So there are three developments. One is that we did a webinar on how you can file for arbitration at the National Stock Exchange. Those who filed have got emails from the NSE saying that that option is closed. Now, there was a circular issued by the Securities and Exchange Board of India on 1st of July, which has more or less said that when there is a large broker default and the assets of the broker are too small to cover the claims that are made, then stock exchanges should not allow arbitration. It is put in a very democratic and fair manner, because it says that the first few guys who are smart enough for filing arbitration are the ones who may get an award and get money, while the remaining who wake up to the problem a little later or have difficulty in filing will get nothing. So on the face of it, it seems fair, but it closes a redress option on something where, to my mind, SEBI was not alert. It has a real-time system that should have red flagged these enormous transactions of Anugrah, hasn't done anything. The National Stock Exchange, from what we know, had a complaint in 2019, should have been alert, did not look at it. Then you have these issues of bank guarantees, which Karya has raised in his affidavit. For instance, why did Edelweiss not invoke the bank guarantee? Did it exist? Was it defective? Mysterious question which has to be done by a regulator. We also know that another big broker who is running a similar Ponzi, high returns, claiming to be a genius in derivatives trading, went belly up, called Modex. It took 9 months for NSE to declare this broker a defaulter, and it's only now, after the brokers declared defaulter, that people can file claims and get up to 25 lakhs maximum from the NSE Investor Protection Fund. So what are we looking at? Anugrah investors could have to wait from 6 to 8 months, 9 months maybe, before they see the color of even any residual money that may be remaining, right? So arbitration is closed. They can register a complaint with NICE, but that's a formality because nothing much is going to happen. There are no assets, and what they say is, we have your details. When we declare him a defaulter, we'll come back to you and you can file for just as little as 25 lakhs. Large number of people have invested upwards of 1 crore, and like I said, one family, 150 crore. It's a large amount of money. So what is the way forward? Can they go to the Securities Appellate Tribunal? Now, Advocate Ravi Hegde, who has been filing a lot of cases for these investors and has been very helpful to people who have lost money, says that that option is also closed because there was a Supreme Court ruling in the matter of the National Shared Securities Depository versus SEBI, where they said that SEBI circulars and exchange circulars cannot be challenged. So you cannot go to SAT with a claim that the circular is against our interest. You have to go to the Bombay High Court. Now, in the Bombay High Court, you have two options. One is the arbitration petitions, and the other option, which hasn't been done as yet, may be to file a writ petition, because to my mind, unless you hold everybody in the system accountable, you're going to have the same thing that has happened to investors in half a dozen cases, BMA Wealth, Modex and others that I talked about, which is that you wait for 8 or 9 months. It's a long time. Whatever few assets are there will dissipate. And one article that Moneylife wrote recently was that a colleague of mine, Akshay Nayak, did a search on the MCA website and discovered that Karya and his wife are directors of 6 companies, have investments in real estate. That is an article you can look up also. We show you a chart. All those assets are not even declared in the affidavit in court. What does it mean? It means that you need a serious forensic investigation. You need the economic offences wing of the police to come in. They have come in. There is a complaint registered. They're looking at it. We don't know what's happening. No action has been taken against the promoter so far. There's nothing to stop him alienating assets. We again hear from lawyers that they're trying to get the enforcement directorate in. The best course, to my mind, is for people to try something bold, innovative, and different. Maybe go and file a writ petition in the Bombay High Court and once and for all ask what is happening to all the circulars which talk about disclosures that the broker is supposed to make. Now, if Anugrah investors say that what they got from the broker was different from what was being declared to the National Stock Exchange, based on NSE's own circulars, there are two of them in 2017. One was 20th July and there was another one before that. Funds lying with the brokers had to be adequately monitored by the NSE. Their declarations and disclosures even to investors had to be monitored. Investors say that they haven't been getting them or what has been told to them was different. All this is a slow process and goes into a opaque black hole kind of situation unless people demand maybe a court monitored investigation which says it's not about us alone. Let's find out whether everybody else, a first line regulator, which is NSE, the clearing member, who's this larger member who's made accountable to the clearing corporation, whether the clearing corporation was looking at things like funded FDs or defective bank guarantees. Let's get that whole can of worms out in the open. Let the High Court monitor it. This can only happen if somebody tests the system and files a suit. Over to people who've lost money. They need to get bold and do something. Thank you.